Do you remember the original COVID-19 lockdown when all of New Zealand was forced to stay home for nearly 8 weeks? Did your employer force you to take annual leave during that time? Then a recent decision of the Employment Court on the 15th of August this year may be of interest to you. My name is Eugene Collins of Collins & May Law, and this is Employment Law Watch. Last week, the Employment Court issued a decision in a case involving 3 Carter Holt Harvey employees. They took action against Carter Holt Harvey, who forced them to take 8 days leave during the nationwide lockdown announced by the New Zealand government. It seems such a long time ago, but this decision could affect a lot of workers throughout New Zealand. So what happened? We all know the government announced on the 23rd of March 2020 that we were moving into level 4 lockdown in 2 days' time. All employers in New Zealand had to scramble and work out what to do. Imagine the logistical difficulties for a company the size of Carter Holt Harvey with a large number of employees they had to deal with. Carter Holt elected to pay their employees from the 26th of March to the 8th of April, but from the 9th of April to the 22nd, they required their employees to use up 8 days' leave. They simply sent out an email announcement to all employees who had a work email address, but for those employees that didn't have a work email address, they simply used an instant messenger system they had and sent out a brief mass text. They also placed some announcements on notice boards at their premises. The Employment Court considered Carter Holt's actions in the context of their obligations under the Holidays Act. In particular, Section 18.3 for the Act, which says when holidays are to be taken by the employee, it is to be agreed between the employer and the employee. And Section 19, subsection 1 of the Act, which says if the employer and the employee are unable to reach agreement, then an employer may require an employee to take annual holidays. Now, hovering over both those sections is the requirement of both the employer and employee to deal with each other in good faith. So what did the court say about this? They said that trying to agree on when leave is to be taken involves consultation. And consultation essentially means proposing an agreement, allowing and considering any feedback from the employees before the employer makes a decision. And when you take that and apply it to the terrible situation we all faced in March 2020 and all the pressure the country was under, the court readily acknowledged that pressure but said there was no suspension of employee rights or employer obligations. So irrespective of how much pressure the employer was under, it didn't mean they could bypass those obligations. They needed to consult with their employees before forcing them to take that leave. Carter Holt didn't. And the court said Carter Holt was not entitled to require employees to take annual leave from the 9th of April to the 22nd. Now, this decision is likely to have consequences for a significant number of employees throughout New Zealand. It will, of course, depend on each particular circumstance, and each of those circumstances will need to be carefully considered before deciding whether you may be able to take action against your employer. It is significant, however, and if you were forced to take annual leave and there was no consultation given, give us a call. I'm Eugene Collins, Collins & May.